Good afternoon, Your Honors. Mark Anderson, may it please the Court. Today I'm not going to be discussing algebra. We can discuss simple arithmetic.
That was geometry.
Anyway. The instant matter was a foreclosure case that was commenced on December 17th, 2010. No action was taken to move for default as against the defendant in that action in the year between they filed bankruptcy. That's 1 year. If you account for all the bankruptcies that were filed in that case, there were two. That is 2 years, 6 months, and 29 days. After the final bankruptcy...
So that's from 11 to 14, right?
That's right. And I'm not even accounting for the 33 days in between the two.
Okay.
After that, and in accordance with what the plaintiff says when loss mitigation began, another 2 years passed before loss mitigation even began. That's 3 years. And giving them all credit for loss mitigation as it became due, so from August 16th, 2016 to when they said it was closed was April 6th, 2018. And after that, our motion was filed a couple weeks later for 3215C relief. Since that time, and since that order has been issued on July of 2018, the plaintiff still has not moved for default in this foreclosure action. So I say that in accordance with 3215C, this case has been abandoned. There is no possible way the plaintiff could indicate any sort of sufficient cause for their delay, and they have not even submitted any sort of indication as to a meritorious cause of action through either an affidavit of merit or through a verified complaint. Their summons and complaint was actually verified by an attorney, and attached to the moving papers, the only things indicated in the affidavit were what loss mitigation efforts were undertaken with the defendant.
Loss mitigation efforts? How many times were there settlement efforts in this case?
According to the plaintiff, there were two trial modifications that were offered, which were unsolicited by the defendant. And they were unresponded to. Now, they'll indicate that a short sale was attempted, and in my experience as a real estate attorney, a short sale effort is just sending a package over and seeing whether or not it's approved. This is not a 2-year monumental effort. This is clearly the plaintiff misconstruing what the facts are, and the facts are that giving them all credit for the timing in this, there is still 4 years in a period of default that they did not move for default, and they still have not moved for default.
Could they have moved for default in the presence of a bankruptcy stay?
They could not, Your Honor. There would be a stay in effect in that instance.
Okay.
I will otherwise rely on my papers. I think the 4 years in this instance speaks for itself, and I do think it was an abuse of discretion for the trial court to deny our motion.
It was a discretionary ruling, right?
It is, Your Honor, but there is...
So we will review it under an abuse of discretion standard.
That is correct, Your Honor.
What is the prejudice to the defendant in this case?
The prejudice to the defendant is that they're a defendant in the action. They were a owner of the property at one point, and because they are a defendant in this action, they have a right to bring a 3215C motion.
Right.
The prejudice...
So they haven't paid.
An owner?
Yeah.
I'm sorry.
So they haven't paid. They acknowledge liability, right?
To the extent that this is a valid loan and to the extent that this is a valid foreclosure case, they have not denied.
So there was a letter to Citi back in 2013 where the defendants admitted having fallen behind on the mortgage payments, right?
Well, as Your Honor is aware, that's an offer of settlement that would be inadmissible hearsay. And the Second Department and the First Department have both held that any indication of a short sale that's sent over to a bank is merely an offer of compromise that can't be used against them.
Can we use it as sufficient evidence of a meritorious claim by the bank?
No, Your Honor. That would be an offer of settlement. It'd be inadmissible hearsay. It'd be on...
Inadmissible for any purpose?
It would not be admissible for any other purpose other than to indicate a settlement offer had been offered.
Counsel, are you conceding that your client no longer owns the property?
Yes, Your Honor.
And what impact should that have on this motion?
This would impact their free transferability of their property, which they have done, but may affect it if it should be found that this is still a valid foreclosure case.
No, I meant on your standing to bring them, to pursue the motion?
Well, Your Honor, this is a defendant in a foreclosure action. This has not been discontinued against my client, and they still are an aggrieved party here because they're listed. To this day, they could have discontinued even after the motion was denied, and they still have not done that. And by they, I mean the plaintiff.
Thank you.
May I please the court, Alexandria Kaminsky. I will address first what you inquired about the 2013 communication. It was a hardship letter. It was not an offer of settlement. So a hardship letter stating that he's experienced financial difficulties and admitted to falling behind on the mortgage premises. As well as your point that he does not own the property. He's not an aggrieved party here. A property owner who transfers his or her interest in the property to a third party before making a motion for alternate relief lacks standing to challenge the order now. He deeded the property away April 2nd, 2015. It's since been deeded since then, March 7th of 2018. And under 3215C, there is an exception. When one fails to timely seek a default, it's such as excusable if there is sufficient cause. That's defined as a reasonable excuse, and the cause of action is potentially meritorious.
What is the viable excuse? I'm sorry.
The viable excuse for us is there is a bankruptcy filed, as was previously addressed. It's 936 days. Then there was good faith settlement negotiations. In 2013, there was a short sale attempt. In 2014 through 2018, there was settlement offers and negotiations. This is detailed on pages 161 to 173. And so because of those, we were unable to do anything. And whenever negotiations are present, we cannot move for motions and, something that's against those negotiations. The action is meritorious here too, because as the lower court stated, that merit was demonstrated by the appellant's correspondent to our client when he explained financial difficulties and admitted to falling behind.
So we can use the 2013 letter, you're saying?
Correct.
Okay.
Because basically, a hardship letter is submitted upon a request to be reviewed for modification, short sale, anything like that.
Okay.
And our stance is that the appellant is not prejudiced by any delay here. Appellant, through the bankruptcy, was able to obtain a discharge of all liability to repay his debt. There were settlement negotiations that ranged for years trying to settle this foreclosure. He hasn't owned the premises since 2015, never answered the complaint, and has retained the income that is owed to our client. So it's our stance that the lower court's order should be affirmed.
Thank you. So it's a hardship letter, counsel, not an offer of compromise.
So a hardship, just to clarify, a hardship affidavit is something that is included in a loss mitigation package. And so what they're saying is that it's one document, but it's actually a document that's included with a series of documents.
It's a document that you create to justify a resolution to the underlying non-payment of the mortgage.
No, Your Honor. As you're aware, the foreclosure action prima facie is producing production of the unpaid note, proof of default, and some proof of when they received the note prior to the action being commenced, and nothing other than an attorney affirmation was submitted to prove that. After that, an affidavit was submitted in response to our motion, which merely indicated what loss mitigation efforts had been undertaken. In regards to the standing
You haven't paid maintenance, the mortgage monthly payment since 2010, right?
It was probably before that, Your Honor.
Yeah. So how are you prejudiced?
Your Honor, the issue here is whether or
You even
not...
kept all of the money that you got from the other units, right? So in fact, you have been benefited rather than prejudiced.
What Your Honor is indicating is some sort of unjust enrichment claim that would...
No. I'm just saying, I'm trying to determine what is the prejudice to a defendant who has not paid the mortgage, has not made payments since 2010, and was actually receiving monies that could have been used to make those payments.
Well, first, it hasn't been alleged by the plaintiff that my client received any money for rents or anything of that sort. But to your point about prejudice, there is nothing in 3215C that discusses the issue of prejudice. That's a two-pronged attack, which details whether there's a
I
sufficient
thought
cause.
the record reflects very clearly that the property was a rental property with 4 units. So I'm sure he didn't buy the property so that he could give people free apartments.
I can't speak to the nature of the property, Your Honor, but I do know that I represent a number of different people.
Well, we know, you can speak to the nature. You know it was 4 rental units. It was not a piece of property he lived in.
Right, but Your Honor, that's not the standard for 3215C relief. It's indicating that there has been 1 year since the date of default, which we can check off the box for that, and then it would be on the plaintiff to demonstrate that there was not a sufficient cause for their delay, and there is 4 years of unaccounted for delay in this action, if you account for everything in their analysis. And it is...
They were negotiating settlement, is what I understand from them. They were negotiating with you, and there was a bankruptcy stay for that 3-year period.
Right, but according to their own papers, Your Honor, if I account for all the things that they indicate, based on my math, there is 4 years of unaccounted for time. And for them to say that there was active settlement discussions for a period of 8.5 years is incredulous. The last thing I would...
From 14 to 16, there was no activity. And where are the other 2 years?
There's the year after the case was commenced, there was 0 activity, and there was no discussion whatsoever about what happened between the year 2010 to 2011 between the bankruptcy and the commencement of the case. And there has been 0 discussion about what happened since our motion was filed.
But except that this case started December 16, 2010, and the bankruptcy was filed in 2011. So what year are you talking about?
The action was commenced, Your Honor, on December 17th, 2010. The first bankruptcy was filed on December 19th, 2011. That's over 1 year.
Got it.
So you're saying what they're proposing is incredulous. However, we are reviewing the lower court's decision under an abuse of discretion standard. So
Yes.
how did the court abuse its discretion in crediting that time?
The court abused its discretion by overlooking all of the time that was unargued by the plaintiff. They did not give sufficient excuse for all of the other time. And the other thing is, it is interesting that a bank is actually arguing standing as a defense, because this is not something that was ever raised in the underlying court case. So as a bank is fully aware, if you do not raise standing, you have waived it.
Thank
Thank you,
you.
Your Honor.